there are 3 judgments of this court, 3-member benches, where the Custom Act only then had provided a right of appeal either to the collector or an aggrieved person.
Yes,
the Director Intelligence had filed an appeal. And this court held, and it was the argument of Director that I'm an aggrieved person. This court held, you may have been disappointed with the judgment or the order, but you cannot be an aggrieved person because no personal loss has been suffered. That is how this court, in case of statutory appeals, has interpreted an aggrieved person.
My lord, there's a fundamental distinction. The fundamental distinction is between a statutory appeal arising out of a statute and a statutory appeal arising out of a constitutional remedy against which previously there was no appeal at all. If this interpretation is accepted, and if under Article 184(3) this Honorable Court strikes down any statute, that would mean that there would be no right of appeal at all to the Federation. The other distinction is that over there, it was the officer concerned who had come up in appeal. Over here, not the current incumbent Prime Minister of the country or a particular official or a Director General of NAB in his personal capacity who has come before your Lordship, CPC. The person who has come before your Lordship is the Federation. If the Federation does not have a right to defend its statute, then who else would? And particularly in a case, this was a case where the petitioner had come to this Honorable Court. There was no real controversy before this Honorable Court. The petitioner had not been affected by the operation of any of the provisions of the NAB law. The petitioner had not suffered any grievance against any of the provisions of the NAB law. He had raised, and that's the submission made, which didn't find acceptance by the majority. The petitioner had raised an issue, and the issue raised by was that this violates the fundamental rights. He never maintained that it violated his fundamental rights. He made the Federation a party. The Federation...
Can we go with the propositions? Otherwise, we will not make any headway.
I've only raised a question.
Absolutely, my lord. Everything which your lordship says merits and is worthy of immense consideration.
But
and
our propositions, because
my lord,
respond number one is not hearing this.
My lord, yes.
He may want to hear this.
My lord.
If you formulate the propositions,
my lord, I will.
Then we can send the propositions and then...
My lord, the very first proposition is that during the pendency of the petition, the Practice and Procedure Act was enacted and an application was moved before the Honorable Division Bench that this matter should now be placed before the Committee for Constitution.
Please refer to that application.
My lord, I will. My lord, may I just give your lordship the date? This statute came about on 21st of April 2023. The Federation filed CMA 7066 of 2023. 7066 of 2023. This is dated 28th of August 2023.
Where will we find it? Which page?
My lord, and your lordship will find it at page 402, part 3 of my intra-court appeal.
Four zero?
402, my lord. Part 3 of my intra-court appeal.
Where's the order on this one?
My lord, the order was passed by this Honorable Court.
First, let's read the prayer.
Yes, my lord.
Then
427 onwards, but let me just point out, your lordship will see on page 402, I produced a note. If your lordship will see page 404, I make a specific reference to SCPA 2023. Its provisions are reproduced on page 404. Case law is cited in support in 406 and 407 and 408. I make other submissions as well, and I'll come to that later, and then your Lordship will see the prayer. It is most humbly submitted that the page 413, that the proceedings in the present petition may kindly be adjourned till after final decision in Constitution petitions number 6 to 8 of 2023 regarding validity of the SCPA 2023, or alternatively a full court be constituted to hear this petition.
And the order on this application?
My Lord, the order is at page 427, which is in part 4. It's a split.
4 to
7, my Lord. Part 4.
Page 4 to 7.
4 to 7.
4 to 7, my Lord. My Lord.
Actually, I had not read this order.
Sir.
So can you read the relevant bits that you think are relevant?
First is my submission on page 427. Your Lordship may...
Right, just the operative part of the order.
The operative part of the order, my Lord, paragraph 4 on page 429.
4 to 9.
Paragraph 4. Be that as it may, we are not inclined to comment on the vires of the Procedure Act, which is a matter for the 8-member bench seized of Constitution petitions number such and such to decide. It would be clearly presumptuous of us to assume the outcome on the above issue. However, it should not be ignored that the Procedure Act has been suspended by the orders of 13th of April 2023 and 2nd of May 2023 passed by the 8-member bench. The federal government thereafter in the hearing has neither requested for the recall of these orders nor for their modification. Consequently, so long as these interim orders are in the field, we are of the considered view that the same must be complied. The title Constitution petition has already undergone nearly 50 hearings. Its proceedings have reached the final stage and are near conclusion. The said petition should therefore continue to be heard and decided by the present bench. Any change in the composition of the bench is neither necessary as a matter of law or of propriety, nor is it advisable at this end stage of the case. Indeed, including the case would serve in the public interest, as much of the time and public money have been expended in hearing the instant petition. There is a dissent, my Lord, at page 431. And if your Lordship may see the opening paragraph by my Lord Mr. Justice Syed Mansoor Ali Shah, I raised the following question during the hearing of this case on 18th August. Whether this bench should continue hearing this case, or should this case be adjourned till the court first decides the constitutionality of the Supreme Court Practice and Procedure Act 2023, or in the alternate, should a full court hear this case pending decision on constitutionality of this court. Then His Lordship gives the reasons what transpired that day. Paragraph 5, His Lordship refers to my submission. The Learned Counsel for the Federation has argued in favor of adjourning the hearing of the present case till decision on the constitutionality of the Act, or in the alternate, constituting a full court bench to hear it, mostly for the same reasons as recorded in my last order and reiterated above, and no satisfactory answer has been put forth by the Learned Counsel for the petitioner to the proposition recorded therein, that if ultimately the court upholds the constitutional validity of the Act, any decision given in the present case by this bench, which is not constituted as per the procedure prescribed in the Act and of the strength of judges required under the Act, may arguably be quorum non juris and thus a nullity in the eye of law. The order of my learned brothers I submit most respectfully does not address this concern either. Even they note in their order that it would clearly be presumptuous of us to assume the outcome of the above issue. The decision of the constitutional validity of the Act is an equally possible decision with that of its constitutional invalidity. It is not a presumption or speculation. No one can be sure of either of the decisions before pronouncement of the same by the bench concerned. Further, it is not the matter of compliance or non-compliance of the interim order passed by the 8-member bench, which is only of temporary nature. The real concern is the effect of the possible final outcome of the constitutional validity of the Act on the present proceedings and any decision given therein. There is a possibility that the instant proceedings and the decision given therein may become quorum non judice and a nullity in the eye of law if the constitutionality of sections 3 and 4 of the Act is upheld by the other bench. So this Damocles sword hanging over these proceedings can easily be removed if either we await the decision of the 8-member bench on the constitutionality of the Act or make it ineffective by placing the matter before a full court bench. The interim order of the 8-member bench suspending the Act was passed on 13th April 2023, more than 4 months ago, and there is no next date of hearing fixed in the case. This unnecessary delay in adjudicating a matter which directly deals with the core functioning of this court is not understandable. Considering that almost 50 hearings have been held in the instant case, it therefore doubly requires that the constitutionality of the Act be decided first as the earliest, so that the court can function in accordance with law rather than under the uncertainty of a stay order. I therefore maintain my earlier view in my note of 22nd June 2023.
What was your ground for constitution of larger bench or for staying the proceedings?
My Lord,
Your ground, what on which?
my Lord, section 3 and 4 of the Practice and Procedure Act.
4 talks about interpretation of constitution. Whether any constitutional interpretation was required in this case?
Yes, my Lord, because they were asking for the striking down of several procedures, provisions of the NAB Amendment Act on the touchstone of the Constitution. The argument being made was that it violates a number of provisions of the Constitution, the provisions relating to fundamental rights, provision relating to Islamic provisions, provisions relating to power of and authority of Parliament, provisions relating to virtually how a power is to be exercised. All of those were in question.
There's also another ground, speaking for myself,
My Lord,
where a larger bench should have heard this case, and that was the question of maintainability, because in high courts certain petitions were pending challenging the Wairis, and the judgment of the majority did refer to the Benazir Bhutto's case, PLD 1988, Supreme Court 416, which is, I believe, an 11-member bench.
my Lord,
And that is the law till today.
my Lord.
And again, this court is ignoring that law. So either that was binding and had to be followed, so any departure that was required to be made had to be heard by a larger bench.
My Lord,
So that is...
may I respectfully am very grateful for that observation. I had spent an entire day arguing Manzoor Ilahi and arguing on the basis of Benazir Bhutto and pointing out that there was a petition pending under Article 199 of the Constitution before the Islamabad High Court, and in view of the pendency of that petition and in view of these two judgments,
You see, regardless of that, Makhdoom Saab, with great respect, the larger bench judgment is binding even on this bench, because that's an 11-member bench.
yes, my Lord.
And Manzoor Ilahi's case has been reaffirmed by
my
them.
Lord. Yes,
and
my
that is the law.
Yes,
and
my
that law is again and again ignored.
Yes,
and that was also ignored in the election matter, to which the majority has made a reference.
My Lord, yes.
So that could not have been overruled, and till that is not overruled, 184(3) petitions are not maintainable if matters are pending before the high courts.
My Lord, even before the Practice and Procedure Act was enacted, That was a submission made by me before the honorable three-member bench of this honorable court, and that was my next point, which your lordships has encapsulated far better than I could.
Arguments, we will hear you later. This is your main arguments.
My lord, that's my second argument after the Practice and Procedure Act. The second argument,
What is the first?
my lord, the first was that in view,
What is the first proposition?
the first proposition is that in view of the provisions of the Practice and Procedure Act 2023, the proceedings before this honorable court's three-member bench had become quorum non judice, and the matter should have been referred to a committee.
So are you saying this judgment is a nullity in law?
That's what I'm submitting, my lord.
What do you say about when the Practice and Procedure Act was suspended? It was not in field.
My lord, your lordships knows it better than me that an order of stay operates inter partes. It operated between them, and my lord, Mr. Justice Syed Mansoor Ali Shah refers to my submission and encapsulates this very well, that if tomorrow this Practice and Procedure Act will be upheld, the stay order will be vacated, and for that period.
So you were prescient, or was Justice Shah prescient?
My lord, this
Or both of you?
The members of this honorable bench are always prescient.
Makhdoom Saab, speaking for myself, the petition was not maintainable in the light of the law laid down by the Benazir Bhutto's case.
My lord, and that was my submission even prior to the 2023 Act, because the Act came in between. And
चलिए ये
that's
एक
my-
proposition हो गया, अगला
Sir,
proposition
अगला
है?
proposition ये है कि on the same issue, a constitution petition under Article 199 of the Constitution, being petition number 2557 of 2022, challenging the various of the law, was pending before the Islamabad.
So I'm just thinking aloud, don't read too much into my observations. It could be that a petition comes here
My lord.
and someone, just to stop that, files a petition in the High Court. Okay, it could be completely mala fide. Okay, how would we know it? We can't know mala fides and bona fides, and that will happen. So should that not be a matter of case-to-case basis, just because a petition has been filed? Or, for instance, some things are time-related. Like, it's very important something happens and a party is not interested in adhering to a certain time. Let's take elections, for instance. So they file a petition, one in Balochistan, one in Sindh, etc. And someone files who's actually interested in elections in the Supreme Court. So the Supreme Court should say, hang on, let's debate those. But they will effectively get the relief what they wanted, delay. So should it be binding on us to that extent, or we have to actually consider the merits of each case, whether in this matter, we should await the decision of the High Court? No, the heavens won't fall. We can easily await it. In some other matter, no, we must proceed immediately and decide it.
My lord,
or is there a hard and fast rule we have to follow?
no, my lord, even in Benazir Bhutto's case,
We want to hear your view.
No, may I just point out what this honorable court has observed? In Benazir Bhutto's case, their lordships described the principles in Manzoor Ilahi as the salutary principle, but in the facts and circumstances of the case, did not follow that route, did not pursue the route. They created a distinction. So what your lordship is observing, your lordship will look at the facts of the case, but over here, it was not a case where to divert the proceedings from this honorable court to the Islamabad High Court. This petition was filed. The Islamabad petition had predated this. That petition was filed by the Islamabad High Court Bar Association. It was not filed by any surrogate petitioner, and it was pending the hearing, and that objection was raised at the very first stage before this honorable court, that the Benazir Bhutto's